all fronts tonight. Yeah, we are here tonight. Land and reparatory justice, the Browns case, and yeah, this is on all fronts legal case. We stay consistent with this case. We've been following this case, and in studio tonight, the Brown family representative. Let me put it that way. George Brown is in studio tonight. Good night, my brother.
Yes, good evening.
We're discussing the Brown case, and I frame it as for Black sustainable futures, because that's what this case represents to me, Black sustainable futures. And let me just place that in context. You know, for as long as this family, well, I've had you're one of the, what's his number 5? This is
4 or 5.
4 or 5. Yeah. And so we're staying consistent. And I'll say this here, George, credit to you and your family. I think it's very important. And many will say that, hey, it's a battle not to be won or can't be won. And I tell people, well, hey, sometimes victory comes in many shapes, sizes, and manners. Whether this is a case to be won or a case to be unveiling, I don't know, what? New evidence? Yeah, new evidence. And we're going to unpack the latest in terms of, you saw it in the newspaper, in terms of land grab case dismissed, the ruling being made. But let me just start off with you, George. Always welcome back, my brother.
Yes, thank you for having me, and good evening to the listening audience. And thank you for always having me on all fronts to keep this pursuit of justice alive and well. Yeah. And also thanks to Mr. Glenn Blakeney for always allowing it to happen.
Yeah, and we are always appreciative to Mr. Glenn Blakeney and the whole Inter-Island Communications family, as we do it on Magic 102.7 and, of course, all the networks.
Yes.
Of 107.5, all of the above. But I'm just going to go right for the jugular on some things tonight, George.
Yes.
And I say, listening audience, allow George and I to unveil and dialogue about some things. And we're going to go some spaces and places, because if you see within the context of the title, land grab and reparatory justice, yeah, part of the appeal to me is this is a case that where argument of reparations is built into it, believe it or not. Mm-hmm. Right? And I'll say this here, this case, and I've said it before, we have linked this case to a case in the U.S. that was in the Carolinas, I think in North or South Carolina, where it was comparable. And that was a landmark case there where it was won by the plaintiff. Also, when right now, when we think in terms of all this talk about full membership into CARICOM, and then what is it that we stand to acquire or get out of a CARICOM relationship, right? Well, as associate members, we have that connection. But interestingly, across the Caribbean right now and throughout CARICOM, there are comparable land grab cases going on. A number of them are deep rooted in the historical nature, such as your case, mm-hmm. right? Some of them are certainly contemporary land grab cases. I mean, Jamaica right now, I know there's big issues going on in Jamaica right now where their beaches are being under occupation, I'm going to call it that, or got some land grabbing going on there. And there are those, I think Barbados has a couple of land grab cases going on. Where else? Bermuda, land grab case. And, you know, when you think in terms of the series of hurricanes that occurred in the Caribbean in the past 2, 3, 4, 5 years. New land grab cases emerge out of that. Yeah. So what I like for us to do, listening audience, George and I are going to have some conversation, and we'll engage you and pull you into it at the top of the hour. But I'm just going to start off with the possible grounds for appeal, of appeal.
Sure.
Because you make it very clear. Oh, we will be appealing, right? We will be appealing. And starting off, the judge improperly resolved disputed facts at the strikeout stage. Now, I make that statement after somewhat of an analysis of much of this is on the article, the last article. And like I said, I'm not just resting statements being made coming out of that article, because you have shared more intimate case scenarios that comes out of the commission, court appeals, all of that. But it is clear the judge improperly resolved disputed facts at the strikeout stage. Now, what do we mean by that? Let me put it in context, and then you join in there.
Sure.
And add your perspective. A central appeal argument, for example, could be the court went beyond determining whether the pleadings disclosed a viable cause of action. Instead, it effectively made factual findings that no fiduciary duty existed, that there was no factual basis for concealment, and that the new evidence lacked sufficient significance. Now, this is coming out of the article. Yeah? Had me looking and thinking. I said, okay, man, I mean, the Browns have been on this case. What's some of the arguments that they could bring forward in this here? Well, one, the Browns can argue that the existence and scope of fiduciary obligations. They can argue that whether concealment actually occurred. They can argue whether fraud toiled limitation periods. They can argue that and whether fresh evidence changes the legal picture. Yeah? These are things where there are possible grounds of appeal.
Indeed.
Indeed. No, I'm just starting this off. You've done yours.
Yes.
What are you bringing to this here?
Okay. Well, what I want to bring here to the listening audience is, first and foremost, I just want to go back to your opening statement where you mentioned about victory. And victory for me and my family comes in many different forms.
Go ahead.
And I'm convinced we already have victory. And reason being, I go back to my mom's homegoing. Her just smiling at me. I knew she already knew victory was there. Victory is there. It's the only thing that's left is the truth needs to be told. It needs to be unburied.
Right.
And what I want to just do right now is give some comfort to my family.
All
because, you know, it's been a long pursuit of justice even to get to this point. It's been going on for 50 years. Voices have never been heard. Everything's always been struck out for procedural and technicalities.
Yeah.
Now, that big headlines in the paper where the case got dismissed, you know, we were all hoping for closure and to honor what our great late uncle, John Augustus Alexander Virgil, intended for his loving family. This setback stings. It really does. But it doesn't change who we are or what we stand for. I personally will not waver. My brother Charles will personally not waver, and we are going to continue this pursuit of justice. I will continue this pursuit of justice for my uncle's sake, for our family's sake, and also to be a voice for the voiceless and the marginalized. On all fronts, we stand firm for Uncle John, for each other. and for the truth that deserves to be heard. Now, you know, my position is such that we filed our special endorsement of summons back in 2024. The bank asked for it to be struck out. We had a strikeout hearing in April of 25, April 21st. The hearing lasted all day. It was based on whether the matter was frivolous and vexation, abuse of process, or no cause of action. At the conclusion of that hearing, the judge, the Honorable Chief Justice Larry Marston, indicated that he will have an answer within several weeks. We waited patiently. We waited very patiently. We respected the courts. 6 months went by. We wrote to the courts in October of 2025. They indicated to us they'd have a decision in December of 2025. The first week of December. That passed. And in the meantime, we had lost beneficiaries. So it's been painstaking.
Right.
At the beginning of 2026, March 27, we wrote another letter to the courts. And the letter we got back from the courts was that they will commence the judgment as of April 26. And my understanding of commence means that they're going to start this judgment a year later. And to me, that goes to the heart of what the courts don't stand for in a strikeout application. A strikeout application is meant to be decisive and swift, to not waste the court's time, the parties involved, and be put to expense. So 13 months, in my opinion, was excessively delayed, along with 3 misindicated dates. So when we got the judgment, I read it, I digested it, and to me, it was very thin. It was very thin. And when I say thin, it appears
without some substance, you say?
Yes, and it appears that the judgment was one way, based on the bank's authority, based on representation.
I guess that's why probably they didn't offer any response to it.
Rather than the actual documentation power that me and my brother submitted.
Got you.
You understand? So we analyzed the judgment, and my family has been engaged in this long legal proceeding before the courts for over 50 years. Never had the chance for their voices to be heard. My mother, was uneducated. She had to drop out of high school at the age of 12. She had to take care of her family. And I'm not saying ignorance of the law means anything, but the bottom line is her voice was never been heard. So me and my brother Charles, we were diligent enough to pursue it. And we got to the point where the bank wanted the matter struck out. So when the judgment came in, after 13 months, it was 46 pages. And I reiterate that it regurgitated what the bank said. It looked like the judgment just adapted the bank's narrative wholesale. Me and my brother Charles, we submitted so much evidence. And in my opinion, that evidence hasn't been tested under the legal basis. That's just in my opinion, and that matter would be for the Court of Appeals to decide.
But let me just interject, because it's more than your opinion, because a clear deconstruction of what's in the papers, for example, and even some things that you just raised, point to some mischaracterization of even the Commission of Inquiry findings.
Correct.
Because Justice Mussenden reportedly said the Commission raised a question rather than a conclusion, right?
Correct. He made an assumption.
Yeah. And as appellants, I mean, you and we had some earlier conversation prior to show, and we talked about some of this, and you said this can be countered. For example, the commission explicitly concluded that there was a criminal conspiracy. The commission,
yes.
Conveyancing documents were forged. Yeah?
Mm-hmm.
Investigations were flawed. And institutional failures occurred. In your appeal, you could argue the judge minimized or misread the report. And that's part of some of your claim of assumptions.
Right. So when I mention about, in my opinion, as far as where I'm saying the judgment, in my opinion, adapted the bank's narrative wholesale. But in doing that, it did not address the material evidence, particularly out of the Commission of Inquiry. It contained limited analysis of the applicable law. For instance, and this is huge. The special endorsed writ of summons back in 2024 was pursuant to the Trustees Act 1876. And we agree with that because the will got signed in 1962. The bank was appointed executors. Their fiduciary duty came into play in 1972 upon his death. That was the law at the time. However, our claim with the bank isn't so much to do with what happened prior to his death in regards to the fraudulent transactions and the falsified signatures or whatever. It's to do with the bank's reckless conduct and deliberately concealment in that 78 report. And that's the analysis Marsden turned a blind eye to. Chief Justice Marsden turned a blind eye to. And when I say that, because the conduct of the bank took place during the 70s, 80s, and 90s. That 1876 Act got repealed in 1974. That act is dead. So our claim analysis should have been under the 1975 Trustees Act, and he didn't do any analysis with that.
You're raising then, and those of you out there who are legal minds and legal heads, and those of you who are certainly well versed in the law, you're bringing up errors in the law, right?
Grounds for appeal of the errors in the law, yeah.
And I know, again, in linking some of what you just said, because one of the strong things that we were getting at prior to was the error in the law concerning some of the fiduciary duties of an executor bank, right? And if anything, this is probably the strongest legal battleground. And this gets us right back to Marsden. Apparently, the judge may have held the bank owed no fiduciary duty regarding the real property under legislation.
We agree with that. We agree with that.
Right.
What we don't agree with, and that falls under the 1876 Act.
Right.
What we don't agree with is the new law that's in place, which is the 1975 Trustees Act. And that's what the bank's conduct should have been governed under. And there is no analysis in the judgment in that regard. No analysis whatsoever. No legal test was tested in that regard.
Which would imply also what? That the executors inherently owe fiduciary duties.
Correct.
Yeah.
And the duty came into play effectively upon his death in 1972. So they made the argument that it was no fiduciary duty prior to his death. We agree with that.
Let me ask, and I'm saying let me ask this, but I know some of this in terms of things I've researched and read that's probably connected to also documents that you shared with me and things that I've added to it. I mean, we know an executor traditionally owes duty to preserving the estate assets, investigate suspicious transactions, act loyally for beneficiaries, avoid conflicts, and account fully. These are some of the things that your family has brought into question.
Correct.
Of the bank.
Correct.
Yeah.
And just out of respect for the courts, I don't personally want to go into the evidence per se tonight. But what I want to talk about is the errors in law.
Go ahead.
And
elaborate some more.
Yes, the error in law is several of them, and I'll just go through at least 8 of them that I have here tonight.
Go ahead.
Failure to consider material evidence. In the judgment, it says no evidence was found connecting Robert Bermuda to this matter. The court's own file contains a cost bill. The cost bill includes a 1993 per usual opinion of Robert Bermuda tying him to this matter. The opinion directly connects Bermuda to the facts in issue. The judgment overlooked evidence in his own records. They're saying, the judgment is saying there is no evidence tying Bermuda. He was the lead counsel for Appleby at the time. He was the lead counsel for Bank of Butterfield at the time. He was the attorney that signed off on the will, and he was the one that gave his opinion on the 78 report. And that's our statement of claim that didn't even get tested. The judgment says there's no evidence connecting Bermuda.
But also in this here, with their failure to investigate even deeper, this in itself constitutes a breach.
Of course.
Right? This constitutes a breach in terms of, and I hear what you're saying, your axe is not to grind the bank per se. Well, no, that's not what you said. It's mainly it's not about a victory over the bank. It's to really point out these breaches.
Correct. And
in the errors of the law.
Sure. And what the judgment is also depicting is conflating the fraud. The judgment says, the Browns have always said it's been fraud. Well, it was fraud on the ownership of property, yes. But Butterfield Bank as the executors, with their miraculous conduct in saying that they can direct their minds to the authenticity of the deeds that are in front of them, and that there is a conveyance that exists but is missing, it's concealment. That's deliberate concealment. It's missing because we still have the original deeds today. There is no conveyance. So, where I'm feeling that the judgment has grounds for an error on ground one is the fact that the judgment does make no mention of the 1975 Trustee Act, and that conduct falls under that act, not the 1876. That's how the judgment is reading to give the bank the pass that they had no fiduciary duty based on all what happened prior to his death. So I can go on with more grounds that we would like to share with the listening audience.
Well, you're saying there were several errors of law.
Yeah, I'm just going to run through them.
And let me just say, because in it, we heard you mentioned about fraud. Well, it's clear on the Browns' side. I mean, when you think in terms of, and it made me reflect upon Judge Musselden's allegations or statement that the argument that the family yourself were bringing forward was stale because similar fraud allegations existed decades ago.
Good point.
But as it is a good point, it leaves
from you. Good point.
Yeah. But it leaves open for you to, when you talk about the fraud is concealed, or fraud concealed the cause of action, because that's a statement in the article where fraud concealed the cause of action. The Brown, as you can make the claim that a fraud claim does not become stale merely because suspicions existed earlier. The key issue out of this from with the Browns becomes when sufficient evidence emerged to reasonably establish fraud. And this is something that you brought up earlier in terms of evidence. Not all the evidence has been forthcoming or being allowed to be presented by you.
Let me tell you what's even awkward here. Because there's definitely something awkward in this judgment internally about this ruling.
Go ahead.
Because on the one hand, the judgment states that the court did not grant Butterfield Bank statute of limitations. He mentioned that the Bronx was able to supersede that.
Right.
But yet, on the other hand, he's calling the claim stale. It's confusing. That's a tension at a minimum that needs to be reasoned out. And the ruling doesn't reason it out.
Yeah.
He can't call the claim stale after he's saying there is no statute of limitation barred.
Or stale in the sense, while the claim by Justice Marsden can be that the allegation is old, again, what's been consistent with you, and even in our conversation, is that, the allegation may be old, but the evidence
there you go.
Is new.
Right. There's two separate entities, allegations and evidence.
There's evidence that is new, and evidence that is new that hasn't been brought forward, which I believe is your grounds for appeal.
Correct.
Yeah? That's something that's legally significant of your case.
Let me tell you what else is also mind-blowing in this judgment. The judgment says that the bank owed no fiduciary duty. The judgment held the bank owed no fiduciary duty. It relied on a 1978 letter from the bank. However, the bank wrote to us in 2023 and in September of 2024, and in both of those letters, the bank stated that it exceeded its fiduciary duty. A party's written admission, the bank's written admission of duty, cannot be ignored as a matter of law. On the one hand, the judgment is saying there was no fiduciary duty. But yet, when the bank wrote to us, they said they exceeded the fiduciary duty. So how does a written admission of duty be ignored as a matter of law? So you see where I'm saying that, to me, this judgment was all to do about the bank's authority power, as opposed to the documented power that me and my brother Charles submitted to the courts. So in other words, a narrative has been created with this claim. And that's for the Court of Appeals to decide on. Because when you look at even the next era of law that we will be contemplating appealing,
go ahead,
is the application of repeal legislation.
Elaborate on that.
Well, the judgment applied the Trustees Act, 1876. The act was repealed in 1975. All of this reckless conduct and our claim of concealment happened in the late 70s into the 90s. And the governing statute is the Trustees Act 1975. Because the 19 Act materially altered the trustees' duties. A claim cannot be determined under repealed law. That's an error of law in itself. That's an error in law by itself. Also, like you had mentioned earlier, the failure to consider the Commission of Inquiry's findings. The Commission of Inquiry found the bank ought to have conducted a thorough investigation regarding the 1978 report. That finding is relevant to reckless conduct and breach of duty. The judgment does not address any of that. Material findings cannot be disregarded. These are material findings that we submitted, and it never got addressed.
Yeah, you talk about breach of duty, and again, elaborating on this possible sustaining claim for breach of fiduciary duty. And as I went into your documents and pulling from the latest ruling, rated against previous things that were stated, right? One of the things, and let me just read this. It says, To survive strikeout, the plaintiffs likely need a narrower and more precisely framed fiduciary claim, right?
Mm-hmm.
And it was, in research and using even some AI in some key questions that come out of what was written, it was stating to me that the strongest version may not be that the bank stole the land. Instead, the bank, as executor and fiduciary, failed to properly investigate and recover estate assets in circumstances indicating fraud.
And that's where the 1975 Act comes into play. And there is no legal analysis whatsoever in that judgment in that regard.
Wow.
Let me tell you what is also very...
That's a more legally sustainable theory.
Sure. Let me tell you what else is very glaring.
Go ahead.
Very glaring.
Mm-hmm.
At in the conclusion of the judgment, it says, I also found that the beneficiaries should not be allowed to proceed with fresh proceedings until the course of the 1991 claim course order are paid in full. Now, would you believe that that claim order form was not entered in evidence? It's the court's admission, as well as the respondent's admission, that claim order cannot be found because it's in the Earl Courthouse with mailed and it's probably been destroyed. So how do you give judgment on a court order that doesn't exist and prevent us from bringing fresh proceedings? How do you give judgment on a court order by the judgments, earned admissions, and the respondents that this order does not exist? It wasn't entered into evidence.
You guys were very bold about, it was no blinking. Let me put it that way.
Well,
in your response that, oh no, there will be appeal.
I'll tell you why there's no blinking. At my mother's home again, I said it. I'm fearless. I'm fearless because I personally, I'm not been the best outstanding citizen all my life, but what I do know is I'm not prepared to let the truth be buried in the judicial system. I'm just not.
Right. And I can appreciate that. I respect that. Let me ask this question in that where is the balance between your statement that may come across, as you just stated, as emotion versus reasoning?
Well, the emotions fuels my reasoning.
Go ahead.
Because if I'm not emotional about it, I'm not totally engaged.
All right.
So I get emotional because I look back at my mother's fight.
Right.
I look back at when I first was able to understand English and listen to what she was really talking about. I just read about this land that she played on growing up. This land that belonged to her great uncle, John Augustus Alexander Virgil. So I'm emotionally involved in that regard, but I'm smart enough to know that emotions don't fly in court.
Gotcha.
So we're coming with the evidence, we're coming with the law.
I was that's where I wanted to zero in on, because I want folk to place that in context. As your passion is your passion, your conviction and purpose is just that. And yes, it will have emotion. And some will say, well, that emotion could be somewhat of the biggest obstacle to your appeal.
Well, at this juncture, what I see as the biggest obstacle to the appeal is that the wrong law was the right law wasn't applied, and the legal test wasn't applied. And that's going to be a matter for the courts of appeal to decide. And I have all the faith and highest respect for the Court of Appeals, because that's what they're there for, to correct, to repair, to make it right. I'm not even criticizing Judge Masterton I'm criticizing the judgment. I'm criticizing the delay. For us to wait 13 months for a strikeout hearing, not even a trial, with 3 misindicated dates, and then the analysis is thin.
And then to dismiss.
And to dismiss, and not even touch on a lot of our submissions other than, like I said, it looks like it was regurgitated. Following the bank's lead as opposed to the evidence.
Well, again, given the ruling, res judicata, it's in layperson's terms, you're just same story, old news.
Well, and that's probably been our biggest battle, because our voices have never been heard. Res judica, which is the Latin term for rehearsing the same claims, that's far from what's happening here. The matter has always been struck out for procedures and technicalities, never based on the merits. Never based on the merits.
And even in response to the biggest obstacle, again, going to the emotions issue, a major problem for the Browns would be, is like, it's not a moral issue. It's not moral force, but a procedural finality. This is in legal terms. And let me just read this. Appellate courts strongly protect, this is already established in the ruling, finality of litigation, right? That's the ruling. This has already been litigated. We're not bringing this up anymore. Abuse of process doctrine and res judicata principles. That's what's been argued and put there on the table. So your appeal probably succeeds only if and when you show, and again, we are reiterating this here, materially new evidence, and a legally distinct cause of action, right? Or that the strikeout judge improperly decided factual disputes prematurely. That last one is something that has been of concern, because even in our, you asked me an essential question. You said you asked me earlier before we started. We had some preliminary conversation, and you said you read the article, Lou. Why do you think Judge Musselman struck it out? Given that his argument or his rationale is based on so-called facts from what was, without allowing for new evidence. Go ahead.
Correct. And let's just revisit the res judica, because that's part of why it was struck out. And our position is such that it's a misapplication of the res judica.
On whose part? Again,
the judgment. The judge.
Got you.
The judgment.
Right. Okay.
The judgment treated the claims as previously litigated. The material evidence in this case emerged out of the Commission of Inquiry in 2021. The evidence was not available in prior proceedings. Res judica does not apply where new material evidence arise. New evidence creates new facts. New facts constitute a new claim. And for him, and I'm not criticizing, I'm just going by the judgment. For him to rest his hat on res judica, saying that this matter has been heard before, based on the amended statement of claim that he read, well, guess what? That statement of claim never reached trial because the matter was struck out, because in 1991, the judge at the time struck it out because plaintiffs did not pay a court cost. And res judica says that the same material facts have been litigated in the past. But it's the banks and the courts' own words.
But they
can't find the court order.
Yeah, but it says without...
So no, but if they can't find the court order, how could they say it's res judicata? Because it was never decided on the merits. It was decided on technicality, the court cause. And that was our position. And no test was made of that in the judgment.
You said on technicality of...
Well, procedures and technicalities.
Okay.
Whenever you take someone to court, if the prior proceedings had to deal with court costs, one can make the argument that no, you can't bring fresh proceedings until the court cost is paid, and that's the argument they made in '91. However, no one can find the order. So how is it res judicata if there was no order in front of the courts to determine how the case ended? Whether it was based on the merits or based on technicalities. There's no evidence in the judgment, because it's the words that it is filed where the ill court is mauled and destroyed. So that's why this is a tribal issue that we'll be asking for. Got you.
And this is a question out there for legal minds, lawyers. Let me put it this way. If this let's say the appeal probably succeeds only if you show materially new evidence and a legally distinct cause of action, and it's that term, a legally distinct cause of action. I really like lawyer or someone to define that for us in the legal term, so laypersons can understand it. I'll be, when we go to open at the top of the hour, and I'll bring it up. But that one that stood out for me, a legally distinct cause of action, would be needed for this appeal, for your appeal to succeed. And I wanted, I really like to hear from a legal mind out there, or even persons, those of you who have been through it, where you understand, a legal, what will constitute a legal distinct cause of action in this case.
Right.
Yeah.
Well, what I will tell you, what my family will be focusing on with the appeal we're pending to put forward is that the judgment's conclusion states generally, in my view, this is a case where it is plain and obvious that the writ should be struck out for reasons as stated above. I don't know how they're coming to their conclusion that it's plain and obvious, but hey. And then it says the writ discloses no reasonable cause of action because the plaintiffs have no viable claim. The plaintiffs have no viable claim based on the judgment, because the judgment is based on grounds of error. Because the viable claim will come from the 1975 Act, not the 1876 Act. The 1876 Act protects the bank as a fiduciary. I get that. But the viable claim is born out of the 1975 Act. Because that's where you have to apply the new law at the time.
So, and again, by applying the new law and speaking to the case in the context of the 70, what do you say, the 19?
Well, from the mid-70s into the 90s. That was the bank's...
Yeah.
We brought a claim based on the bank's reckless conduct rises to the level of fraud. So that's what I'm talking about, where the judgment is conflating fraud. They're saying, oh, fraud's always been mentioned. Well, it should be. My mother slept with damn deeds all her life. So, like I said, she wasn't educated to articulate, but she had the deeds. And that was fraud in her mind, because how could, she not get her rightful inheritance if she has deeds to the property and a will was executed indicating that John Augustus Alexander Virgin bequeathed this land to the 7 beneficiaries.
This is this the complexity of this case. I mean, it's got a lot of, for me, given the fight for as long as you've been in this fight, and to see where we have arrived right now on the dismissal of clearly understood it being dismissed because you're rehashing old arguments that were already addressed in the Commission of Inquiry. Therefore, there's no need to listen to or hear this case. And again, it's the new evidence.
It's the new evidence?
The old allegation speaks to, or can be said is argued and looking at suspicious behavior. Where the new evidence...
Well, the old argument also, with all due respect, was to deal with the ownership of the property. You understand? Now, born out of the Commission of Inquiry is all to do with how the new evidence came into play. And we have a handwriting expert that came in and
forensic.
verified.
Let me bring this up, because that it brings up the issue. If you're talking new evidence, new evidence would warrant a forensic analysis that proves the bank possessed contradictory internal documents and concealed them, to which that handwriting confirms it. Right. That wasn't allowed, by the way, because let me be clear, in the Commission of Inquiry was forensic evidence provided during Commission of Inquiry to show that
it validates why the bank all these years are saying there is a conveyance that exists but is missing.
That's what's missing.
That's the concealment.
That's the concealment.
That's the concealment.
Got you. Okay.
And that concealment right there should be governed under the 1975 Trustees Act. And this is where our position, the legal test was not...
That's what they say is concealed or that can't be found.
Correct. And our position that is concealed. And I just don't understand how this is not a triable issue. There is...
Wouldn't it rest then on the family to have to prove or bring forward some type of documented written evidence? If they're saying it's concealed, not found,
missing,
isn't it? So it rests on the family really to bring forward evidence of that document.
Right. And another thing, and like I said, I'm just litigant in press, I'm not a lawyer, but what I do know is the political environment at the time in the 70s.
Yeah. Well, there's lots of history of documents going missing.
My family was stacked against the wall with this.
What do you think? What Tucker Town was all about?
Right.
Yeah.
They went to the beneficiaries went to the police department, and in the Commission of Inquiry, it clearly states that the police department failed in the glaring mission of not engaging in a handwriting expert when the investigating officer of the police department, Sergeant Caston at the time, said, listen, we need to get a handwriting expert here to verify. That's all in the public right there. But because of the political environment and so forth, the police department also clears the file. And I'm not saying that I could tie or connect the dots, but what I do know is at that time, and John Swan was involved at the Commission of Inquiry, Sir John Swan, and at the time, he was the Minister for Home Affairs when the police files got closed. So there is disputed facts all the way around where this matter is triable. And when the facts are in dispute, we go to trial.
And
we don't just let in today's world, money, muscle, and power prevail.
Mm-hmm. So, the strongest route for the Browns, and I think I alluded to it earlier, would be instead of an argument that the bank participated in the stealing the land.
That's never been our allegations.
Right. But I'm saying because the judge already found no factual basis for bank involvement in fraud. Right?
Well, hold on. Fraud comes in many different ways. And I can cite case law. It's not so much fraud where somebody took the land and it's fraud. Fraud also derives out of reckless conduct.
Okay, and that brings up
when you could just turn your blind eye to your earned client. They were the executors.
This is the strongest route, then, that you can take. The bank, after assuming fiduciary obligations as executor, breached independent duties owed to beneficiaries, the family.
Correct.
By failing to investigate creditable evidence of forgery and by concealing or mishandling estate recovery efforts. That would shift timing, duties, and legal focus. And it says the key distinction becomes not the original 1960s, 70s conveyance, but the executor's conduct.
There you go.
After Mr. Virgil's death. Yeah?
Correct.
Is brought into question.
Correct.
That may help separate the claim from the earlier title
and
litigation.
That's where I'm saying
where you're going.
The judgment didn't do a proper analysis. They regurgitated everything the bank put forward and created the narrative.
Yeah.
And I will personally go to my grave fighting this case.
So,
and I just want my family to keep hope alive because
that's what warrants the case.
Yeah.
Before the court. Yeah.
Yeah. I just want to say one more time. I just want my family to keep hope alive because this is historic. This is moving mountains. You don't move mountains by getting an easy pass. I'm prepared to go through the fire.
All right. Whoa. Well, you all know the number 297-1050. What she? This 1057 people. You know the number. 888-257-9086. If you're calling via overseas and the lines are lighting up, we're going to engage you, some of the listening audience, and I'll say this here. There's another part of this here because we talked about reparatory justice. Because this is a case, please hold caller, this is a case that has strong arguments for reparatory justice. I mean, we have been talking issues of reparations, and I spoke to, what's going on in the Caribbean. We know what our partnership is with the Caribbean in terms of dealing with issues of reparations. But caller, thanks for your patience. Go ahead. What question you have?
Good evening, Dr. Lou. Good evening to you again.
Good evening, sir.
Good evening.
I'd just like to offer hope and prayers for yourself and your family that you will be able to overcome these difficulties and these injustices. And let me say it this way, is that Almighty God sees all and He knows all. And every last person that's involved in this fraud, whether they be alive or dead, those that are dead and were involved in this fraud, they are getting the hellfire. Those that are still alive and involved in this continuing fraudulent behavior, they too, the day of judgment, they too will get the hellfire for this. If they think that they're gonna escape, even if you're not successful.
I appreciate you sharing. I appreciate you sharing that. I appreciate you sharing that, caller. Because it is, and like I said, George has been very clear. His family's been very clear about their conviction and fight. This is endless to them in terms of seeking justice. But I appreciate the call. Thanks a lot. Good night, you're on all fronts. Oops, I lost you. That was the overseas call. Try again next time. But now the caller, there's like I said, George, no one doubts your family's battle and your confidence to continue to fight. Yeah. Mm-hmm. Good night, you're on all fronts. Turn your radio down. Yeah, go ahead.
Okay, let me 1 second. Okay. Good evening. How are you?
Doing well, sir.
Good evening.
Can you hear me?
Hear you very clearly.
Very well. Good. Listen, I've been listening to the show, and I did read the article in the papers. Mm-hmm. I think it was yesterday or the day before yesterday.
Yeah.
And it seems to me that the court, or let's say Mr. Mustard, is hinging his argument on maybe a couple of things. One in particular is that at the time of the offense, that there was no such thing as a duty of care. Right? There was no duty of care for the executors. The admission that that something was done wrong is clearly, obviously, something was done wrong. Right. But the question was whether or not they were liable, which means that there had to be a duty of care. Right. And what Mr. Muslim is hinging on is that there was no duty of care at the time. Now, George is saying that, in fact, what happened is that in 1975, Trust Act somehow brought in a duty of care, and this offense took place after that. Now, that seems to be the legal battle. Now, I'm going to be concise about what I'm about to say, and that is this. One is, I think the distinct legal action which was called for, simply in lay terms for everyone to understand, and I'm not a lawyer, but the best I can understand that term, it means that the whatever the claim is has to be clearly distinct from whatever the original claim was, right? It has to be a separate argument, clear and distinct from whatever was previously put in front of the court. Another argument, right? And you would have to frame it in such a way that there is another argument to be brought before the court. So that's what that particular thing means. All right. Now, what I want to say is this: one of the purposes of the Commission of Inquiry was to set aside all those issues of statute of limitation, time, and all these sort of things. The thing that a Commission of Inquiry does is it actually resets law. It allows you to look into issues that happened in the past with a fresh lens, without the bias or prejudice or even structural positions that prevent a fresh look at the evidence. So that's what the role of the Commission of Inquiry was. And it to me, and just my lay opinion, that the remedy that the Brown family has possibly falls right within the remit of the Commission of Inquiry, right? That the Commission of Inquiry is not bound and limited to the court. Like whatever the court may find itself structurally unable to sort of remedy this because of time, due process, all sort of maybe structurally unavailable. So if it is unavailable, but yet the Commission of Inquiry can prove that to any lay person, any average individual, listen to the matter, that this is a genuine bona fide theft, right? And the Brown family was done wrong. And the average person can stand up and look and say, they were done wrong. It's clear to us. Right. But the legal system cannot deal with it. The Commission of Inquiry can't. Now, the Commission, unfortunately, claims to be benign. Oh, we're just an advisory board. We can just do so and whatever. And then the Parliament is there to sort of look at what comes out of the Commission to determine if, in fact, something falls outside the scope of the legal system. If it's needed to be remedied, then the Parliament has the power to remedy it. So that's where that thing. That's where I think, in my view, and this is a humble view because I'm not a lawyer.
Right.
Like George, I'm a litigating person myself. So, but it seems to me that the remedy, part of the remedy, is that gives justice to the Brown family is in the hands of the Parliament inquiry, and ultimately in the hands of the Parliament. Mm-hmm. Now, hence the reason for my complaint, in that I was trying to basically prevent the Parliament from having a discussion about it, was because the Parliament is the conclusion of the Commission inquiry. When the process is that once the Commission inquiry has been authorized, and once it does its work, the end process is the Parliament debates it. When the Parliament debates it, then that's the whole facility that allows the Parliament or the redress.
Right.
You call it whatever you want to call it, reparations or whatever you want to call it, the redress.
Right.
Whatever allows that, all that is gone after once the Parliament discusses it. You have another case that comes up. That case has to be tried with the same law that Georgia is dealing with right now. The same court, the same system, the same structural problems that you cannot fix, will not fix. So that's the reason for a commission inquiry. So, and because some of my cases were left out of the loop, wrongfully left out of the loop, I knew that if the Parliament closed the commission, debated it, and closed the commission inquiry, that any avenue that affected the matters that were concerning my family would be locked out and left in the same corridor that George is sitting in right now, trying to hammer on the doors of the legal system, which may be impenetrable. He has to find a new case, and not just simply the new evidence, but that new evidence is be framed in a complete context of a new case that was separate from the fraud case that was presented before.
I appreciate you sharing that. I appreciate you sharing that, giving that clarity. Yeah.
So that's why I want to say that's the role of the commission of inquiry.
Gotcha.
It is not benign.
Right.
Okay.
But again, in your clarity and explanation, there's room in Parliament to bring this to the next level. You're saying also.
Yeah, I'm saying there's room in Parliament to be able to deal with that if the Parliament sees that an injustice has been clearly done and it fits outside the realm of the courts.
I appreciate that. Yeah,
if it's outside, because otherwise, just recommend it to the DPP, as though the Commission has no power, no strength, and recommend it to the DPP. It's going to end up landing you right back in the same spot.
Sure.
Gotcha.
Sure.
All right. Appreciate it, my brother.
I appreciate you for calling.
Yeah.
Thank you.
Thank you.
Yes,
Thank you.
Thank you.
297-1027, 297-1027, 888-257-9086. You'll know fronts. Go ahead.
Yes, good evening.
Good evening.
And this gentleman here, he goes by the name of George?
This is Mr. Brown, sir. What's your question?
No, my question is, I want to address the gentleman here, whatever his name.
I just said it's Mr. Brown, sir.
Okay, Mr. Brown.
Yeah.
Good evening.
So do you want the property back or do you want some money?
I'm seeking justice. And
So
we have no issues with the parties or the persons that are living on the property because they're living up there in their right conscience. They're living up there. They bought these houses, and that's not our issue. Our issue is justice. Our issue is to correct the wrongs of the past.
Okay, so you were dealing with the foreparents were dealing with racist elements at the time.
Mm-hmm.
So you're now coming within our structure here that people are living on the properties aboard. How big is the property, Mr. Brown?
Big button?
How big is this property?
How big is the property?
It's from what I know, it's 23 houses on the property.
Yeah.
Well, guess what? 23 houses. Imagine that back in the day, if your people still had that property, they'll be getting all that rent.
Of course.
From 23 properties. So what? So you with no money?
Well, I'm not willing to discuss that on air.
Yeah,
like I said, I'm seeking justice.
You got to keep in mind that there's still grounds for appeal, and certain things cannot be fully disclosed.
Correct.
Yeah,
Correct.
And that's one of them.
I appreciate the question, but it's justice that we're seeking.
Okay, I understand that. But the people in general, the laymen in general, after finding the real deal, can come and support you. Especially if you're a black gentleman.
Yeah.
You should maybe all the people should maybe come and then help some representatives through the pillar.
Well, I'll say this here.
Yeah.
I'll say this here that there are other families who are fighting, believe it or not, like-minded battles in Bermuda.
Correct. I understand.
So yeah. But I think he's made it clear.
And this is why black people don't get along, you know.
Okay. Well. Let me just say, we hope like we said, we're working on black sustainable future. Appreciate you. Good night, you on all fronts.
Hello, Dr. Lou?
Yes, sir.
Hey, sorry, I couldn't hear you there for a minute.
Go ahead, hear you clearly.
Hey, Mr. Brown.
Yes, good evening.
I understand your battle 100%.
I appreciate that.
Right down to the foundation of your situation. Your battle is going to be hard because you're fighting ghosts from the past, and another thing that's going to happen is that you're going to end up fighting the same system as your mother fought.
Well, let me just say this, because it's like a twofold situation. Personally, I don't feel with this claim that we're fighting the ghosts of the past. With this claim against Butterfield Bank, we're fighting the institution. The ghosts of the past is through that 62, 69 activity.
Correct.
I'm fighting justice, and it's the institution that needs to be held accountable. And it goes right back to the heart of structure back in the 70s, money, muscle, and power. And even in today's world, I'm still seeing that. I see it in this judgment. I see it in this judgment when, the claim is the judgment is a regard. It's dealing with all of the respondents' pleadings and taking none of our pleadings and evidence and done no analysis. And I'll just tell you this, and it is a little bit emotional, but where I still see the money, muscle, and power is that 78 report when the beneficiaries asked for the executives to do an investigation into the title and the chain of real property.
Right.
They said there is a conveyance that's missing, but it exists. Listen to what we say. That's what they said. And in this judgment in 2026, judgment is made on a court order that it's missing.
How could you make a judgment?
That's my point. Read the judgment. It clearly states that. So I'm not criticizing Muslim. What I'm thinking happened here, in my humble opinion, is that me and my brother Charles were litigants in prison, and the power was given to the bank in this litigation.
Okay, because I understand, when I said I understand your battle, because me and my brothers were going through a whole battle, but it's in a different jurisdiction. We just found this out in February when we had a family reunion in St. Kitts.
Oh, wow.
Right? And, when you have family reunions, you meet people that you don't even know your cousins, so whoever they be.
There you
go.
But we met a aunt because my dad and all his brothers are now deceased. So this lady walked up to me and my brothers because we were still having a chat, and she says, I think you guys need this document here. So we looked at one another. So our question to her was, well, who are you? When she turned around and said, oh, I'm your dad's youngest sister. I ain't got no damn autism. Do you? But it went straight left. So,
but she presented you with relevant documents.
She presented us with my dad's father, which was from St. Kitts. A deep plot of 28 acres of property. First of all, we guys looked at it and we didn't think it was a genuine piece of paper. But when we looked at it, it came in a leather case. It was sealed because she said she couldn't open it. So we said, well, how long have you had this? You know, but my dad never went to St. Kitts.
Got you.
My only two of my uncles that I know actually went to St. Kitts.
Right.
So she said she's had it for years. So
but just imagine if you had never gone.
Imagine that. But I understand Mr. Brown's battle because when we went to the courthouse in St. Kitts and we looked up the registration of land in St. Kitts, and we looked at this parcel and we looked at one another. And we both, all of us was like, nah, this is too real.
Wow.
Well, I appreciate you sharing that call because and that experience.
Yeah. But anyhow, let me get off because like I said, we understand, but we're in a different jurisdiction. Fight the same battle.
Yep, and it's connected. Thanks a lot.
There you go. Have a good one.
You too.
Thank you.
You know what it's connected to, and I got to bring this up because again, and it's not far fetched because as the caller said, you're chasing ghosts, right? But in this, and it had me asking the question, and making connections to, like what are some of the core reparatory justice arguments that emerge from this case, right? And there are some key arguments.
Of course.
And again, and I say in this listening audience, please hold, caller. I was saying, with all of our conversation in this island right now about and what the 14th and I think is what the 19th or whatever, there are discussions going to be held on CARICOM full membership. I take conversations and issues like this as some of the pertinent key arguments that can be added to whether you're for, but if you're for, you can bring this into an argument for full membership to CARICOM, right? And I see it as a connection. Just on the caller who just spoke, these are key issues. These are global. These are issues that are going on right now, and given our political discussions right now for CARICOM full membership, it is connected to reparations. It's connected to reparatory justice. And so one of the things that the Browns could argue as it's connected to reparatory justice is a fiduciary institution's continuing refusal to acknowledge, investigate, disclose, account for, or remedy a historical fraudulent dispossession has caused intergenerational harm, people. You've spoken to it. Your brothers, sisters, family have taken on the battle. You got the grandchildren who are engaged and involved in this historical battle.
Yes.
Yeah? And that is connected to intergenerational harm. That is a reparatory justice case. That makes it a reparatory justice case, right? When you think in terms of continuing some of the fiduciary duty rather than historical wrong alone, you could frame this thing again, talk about the bank. What did the bank do after becoming an executor? Those are all reparatory justice questions.
Correct.
Yeah? Another possible argument, reparatory justice argument, an executor's fiduciary obligations do not disappear merely because the original fraud predates probate. Correct. These are reparatory justice points and counterpoints. So, while that has not been a subject of your quote-unquote argument and defense, for actions to be taken, the reparatory justice is another angle to your case.
Yeah, I'm glad you brought up the reparatory justice, because for 50 years, my family has waited for a hearing on the merits.
You hear what I'm saying?
And we're looking to just have all of this repaired.
As much as people talk about, you hear mental health, you hear about trauma, there's a lot of intergenerational harm that has taken place as a result of this case.
Correct.
Right? You're living with it.
Yes.
Every day. And from Virgils to Browns to Browns to Virgils.
Right.
Yeah?
Yeah.
Yeah. Good night, you on all fronts. We're listening. Good night.
Good night, good night.
Yeah, good night.
Yes, very well, the stuff in the house. Now, I want to talk about this issue because I do have a degree in business law. Now, some people having this problem, and all I suggest is try the international courts.
Ah.
Yeah, take it to England or USA. I've got a problem with a former premier who took some money from my family. Mm-hmm. So we'll look at it. No, you can't fight corruption in a corrupt island.
So you're saying you took your case to international court?
Yeah, we're taking it to America.
Okay. So
because you can't fight corruption
let me ask you this. Your case and issue is here, yeah? But you're taking it to international court in America.
Because Bermuda is a corrupt island. Tell me answer.
If your argument is that Bermuda is a corrupt place, and you're taking it to America, who is as corrupt as we witness right now, I'm trying to get clarity in terms of. Go ahead.
In America, a senator cannot become an attorney general and then become a judge.
All right.
And that's what we have today.
All right.
We have corruption in the judiciary. All different powers have to be separate. You separate the legislative from the executive.
Let me ask you this here, given you say
from the judiciary.
Let me ask you this here, given that British law, American law is two different things, and we're in a colony of Britain.
Right.
How do you respond to that? You're saying, well, we certainly won't take it to the United States. But you can say, do we take?
You could put these individuals on the stop list. You understand?
I cannot follow the logic of your argument, recognizing that.
Put you on the stop list. Once that case goes in court,
I can see us taking it to Privy Council in the UK, given we have British law.
Well, I mean, you're saying how could American law if you don't have a president who is in charge of the Congress at the same time? That's what we have in Bermuda.
About the details of the law, and you know law, I think I know enough that there's no way that we can take this case in American law. It doesn't fit in the. It cannot. I can emphatically state it cannot be argued in American law. No more than American law can be in this case.
American law is much superior to Bermuda law.
Okay.
You really have to pay your lawyer in America If you
for someone who said he knows law, I'm telling you, go back to the law books. As as a lay person, I know very well that this is not a case that can be taken to the United States and argued.
Bermuda is a corrupt island.
All right, so, and you're saying, you have a judge. And I'm closing out. Take it from a corrupt island of Bermuda to take it to a corrupt country in America. I'll talk to you later. Peace out. That don't make sense to me. That don't make sense. And using my Section 8 has some good arguments, but that one doesn't fit. Go ahead, George.
I don't feel this case needs to go anywhere. I just think the proper law needs to be applied. I believe that
Privy Council. Well, is this a case that can go to Privy Council?
Well, I'm hoping it doesn't have to go that far because.
But it can, though.
It can, most definitely.
When you take what the caller was saying,
right.
Although he's far-fetched in talking about taking this case to America, if he had said, "No, you take it to the UK and Privy Council," and let me just say this here: we just had the King last week or a couple of weeks ago. Yeah, the King was present, and there was much question about the King. Offering apology and how much the monarchy needs to atone for its theft. Yeah? And issues of reparation, which, of course, when people talk about Parliament, UK Parliament has yet to apologize.
You know what's mind-blowing to me is even like when I walk the streets or I'm just around certain people and we have a conversation about this matter, it seems like we make more sense than when I'm in the court proceedings. And I'll just make a small example, and I'm hoping it makes sense with the listening audience.
Well, this is very complex, I think, for everyday citizenry to
and that's why I'm trying
digest.
And that's why I'm trying to simplify it.
Go ahead.
Meaning,
if you can, go ahead.
You know how in the judgment it says, or even in any court proceedings when you're bringing a claim, it says, you should be doing reasonable diligence and bring your claim when you had knowledge. Bring your claim when you had knowledge. Okay? I agree with them lines along the way, but you're going to tell me in a modernized society where people still have the original deeds, they have a mountain of evidence, and the people's voices aren't being heard because they're saying they make an argument of when you ought to have had reasonable knowledge. Now, the way how I look at it, just talking to people on the street, somebody can get raped in the 60s. And they have reasonable knowledge that they got raped in the 60s, but they bring a claim 25 years later. I don't understand. And then...
And statutory.
Yeah. But yet, when it comes to our generational wealth, we're getting kept at the doorsteps on this legalism. And I believe all of this legalism is really playing out even in today's society. Because just imagine, I said, or mentioned that it's roughly 23 houses on that land. Look at the generational wealth among 7 beneficiaries that were lost out on because of legalism. And I believe even the way it's set up for hiring a lawyer. My family couldn't afford a lawyer in the 70s, 80s, and 90s to take this case. To take this case. And the system structured as no lawyer in Bermuda would even take a case on a pro bono basis.
And again, when you talk about land grab cases and so forth, and we think in terms of, the historic landmark cases out of Tuckerstown, that's always been a frame of reference for many Bermudian people. And it didn't take, it wasn't until the Commission of Inquiry in the 21st century to even address some of those cases.
Of course.
Which gets to your point in terms of only so few who had the capital to contest institutions, really. Because many of these land grab cases are really associated and connected to institutions. Go ahead, caller. Appreciate your patience.
Yes, Lou, I really didn't want to call back.
Go ahead.
Things. One, statute of limitations? Have they ran out on this case?
Well, I will tell you the statute of limitation wasn't awarded to Butterfield Bank. So we got some sort of vindication there. However, the judgment, in my humble opinion, once again, is speaking out of both sides of the mouth. They said the statute of limitations doesn't apply, but there isn't a viable claim because the evidences are stale. The evidence is stale.
And therefore,
it's like
in appeal, you bring forward new evidence.
Correct, but yet they're saying the evidence is stale, but yet they're saying it's statute of limitations.
But what is clear, to answer even the caller's question, so, in this case, the fact that you can bring new evidence allows for case to be heard. And I'll even go as far as saying,
Parliament
question.
Yeah.
Because that's been another issue of yours, that Parliament has the grounds to make the case heard.
Great. 2 points.
In court. 2
points. So, in our claim, we cited statute of limitations, section 3233, deliberate concealment.
Right.
And Butterfield didn't win that argument in the judgment.
Okay.
They didn't win that argument.
Does that answer the question, caller?
Yeah, that does, because then, therefore, if there's not no statute of limitations, or in this case, they did not win the argument or was awarded on that, so that means this case is still should be an ongoing and open situation.
Which it is.
Correct. And I'm not criticizing Judge Marston or the courts, because I'm a layman and I'm off the street, but if I had to explain this judgment to my daughter, to me, it appears the system's being protected.
Well, you're correct, because, like I said, when we went to the court in St. Kitts,
right,
they said that the family should have been aware of this, and it should have been brought forth way back from. But we had to explain to them that all my father's siblings are now passed away. This is knowledge that has just come in the last 4 months ago. So how is it that we're supposed to bring it? So the judge then said, was there a board of inquiry? We had to go back through the notes, and there is a little paragraph that says, Board of Inquiry's decision is, this is way back in 1978. And it said the Board of Inquiry's decision on this matter is that this matter should be an ongoing matter until ratified. End of conversation. It's nowhere it says that this property should be subdivided, sold under any conditions. It says that the heirs of this property should obtain the property, whether they reside or citizens of the island of St. Kitts or not. We are now the heirs, so we now have to bring this battle forward.
Well, I would
that's
even...
That's why I said that. That's why my comment...
Yeah, I think you make a great point, but also I think I'm saying you're in a great space and place, only based upon some of the latest relations that St. Kitts and Nevis have taken on with Bermuda, encouraging and wanting those of us who have extended family, ancestral family from St. Kitts and Nevis can move towards citizenship. But with it also, based upon some things I know from family history of my own, that properties that my elders have and it's still in their name, even though they may have resided or they came to Bermuda and never went back. If that property, this is based on what I've been told by St. Kittians and Nevetians, that it is still in the family name. Therefore, through proof of heir apparent, as you've discussed, through that evidence, you too, through going through the legal process, you show the evidence, can justifiably claim that land.
Mm-hmm. That's correct.
Yeah.
And another thing that we learned was that it's just like we have a land tax office here.
Mm-hmm.
So if the taxes wasn't paid on that property,
right,
now the government now go back and take the property. But our ace in the hole is that we have a relative that was the former Prime Minister of St. Kitts. Do you see what I'm saying?
Right.
So when we went court, and of course Carlos was with us, when we all sat at the bench and the judge looked down, only he says, sir, do you have any business before the court? He says, yes. We are, I'm with my family detesting this problem. And that's where the situation changed from that 4 minutes of conversation.
All right.
You know what I'm saying?
I appreciate you sharing, brother. Yeah.
There's, well, like I said, there's a different jurisdiction, so I'm dealing with a different set of rules, different set of laws.
Okay.
Well, you are and you're not, because, they come under British law too. Although
we're independent country.
As they are an independent country, but it's based on British legal system too, still, from my understanding.
They deal with a lot of British common law.
Yeah.
Yeah, that's right.
So,
okay, no problem.
So all I'm saying is not that far removed from our own.
From our own, that's right.
Yeah.
Okay, thanks, guys.
Appreciate it, man.
Okay.
Yeah.
Thank you.
Mm-hmm. Good night, you're on all fronts.
Yes, good evening. How are you?
Doing well, thank you. Good evening.
Good evening.
I really love your show. This is excellent.
Thank you.
I turn my radio down.
Yeah, I hear the radio. There's a vibration in our ear.
Yes,
Thank you.
You'll be correct in what you said about jurisdictions and the fact that you said even if it was in another island, it would still be a problem. However, because some of these children in Bermuda, family members in Bermuda, did not know their parents.
Which was like one of the things of the caller. Yeah.
Yeah, and so therefore, property that would have come to them would not come to them now because of certain family members that knew this, and they decided to step in. And they decided to collect anyway, knowing that he had children, but they were going to rule that out because the children are not there. And that's why so many things are going wrong as well. Like you could have a lawyer in a family in St. Kitts or somewhere, right? That knows these things, but they're not going to tell you that. So you have to do your research.
Yeah.
When you do your research, you find out whose name's on your documents. And then when you go into your documents and you look at the identity that's on your document, because I don't want to say what I know about that, you can read it and find out for yourself.
Yeah.
Because back in the day, it was only a few people that had deeds. Really was, if you go in the early days, it was only a few people that had all the deeds. And then later on, it got distributed among different people. But those names will be on your deeds.
Yeah.
And if you look for it and you actually read it, you can see how many family members' names were attached to that. And some people that weren't even family is attached to that.
Yeah. Yeah.
So that's how they're able to dwindle these children out of what they earn. Because that's going on today, even in Bermuda and overseas. That's going on today. People know who these children are today, but they're not going to tell them that if something happens to me, this is what I collected. But I'm not going to include you here in Bermuda.
Well, and like I said again, in the case or the example that the previous caller shared, I mean, it was a family member who brought it to their attention, given they visited. And you're right.
Right.
There are family members who, we got enough of our issues here with some of that in Bermuda.
Exactly, but you know what? Bermuda is corrupt, in some things.
Well, again,
let me explain that. When it comes to the land and your dealings here in Bermuda,
right,
there are some people that make sure that you will lose out. There are some
Absolutely.
people that will use the law on you that they think you don't know any better.
You are absolutely correct.
And there are some people here that legally will make you, I'm going to tell you the truth, will make you sign something before you even be in an office and force you to sign it.
And that has
not even having read it.
And that has occurred. I mean, that's what
of course.
you found.
To me.
Some of those things were brought out even in the Tuckerstown land grab cases. I mean,
well,
you know,
it's happened recent, and it's not a joke. We're not stupid. We understand exactly what's going on. But when you go to a legal fraternity, you know what they're going to tell you? Well, no sense fighting that. You must leave out of land, because when you really look at the evidence, because I read a lot, when you look at the evidence, there's somewhat attached too. They ain't going to tell you that, but I find that out.
You're bringing up the question of how have colonial governments, banks, corporations been complicit in land grabs, and Bermuda has a long history of that.
They do.
Yeah, Bermuda.
Because I had an auntie
Bermuda has
an elder that told me some things, and actually, when I looked at the evidence, it's absolutely correct.
They're not just that we have a long history, like you said, we have a long history that you could bring it right to the present day.
Well, we do.
Where when you listen to right now how there are many family homes that are caught up in disputes between them, right? Without a doubt, those disputes are also framed with legal, how can I put it? Not legal interference per se, because they've been allowed to be a part of it, but legal contestation among and between different family members who are challenging each other for what they may deem is theirs, and at the same time,
legal family members. Sometimes I'm telling you, sometimes it's the legal fraternities itself, or something within the departments here in Bermuda. Because if you, let's say, have a set of keys, and somebody else is entrusted to another set of keys, and you find out, let's just say you ran away to school, or you skipped away for all the kids for like 6 months. Then you come back and you find out that your documents, very well were locked up, where they are. There's only 2 people that would know where they are. Why would they be missing? It's only 2 sets of keys.
Yeah.
And in this island, I find that if you talk to enough elders, you find this.
Well, like I said, there's no shortage of cases in Bermuda.
And there's a lot of little things that I could say, but I'll say them to the right people.
I appreciate it. Don't show all your cards. Thanks a lot.
No, I won't. I'm got a lot to say, but I'm just saying, if you look at your documents, you're going to see these names unfilled.
I appreciate you sharing, though. Thanks.
All right, thank you.
Take care. Take care.
Okay, bye-bye.
Yeah. The bank's role as executor matters enormously in these. Even when I look at your case, the family case, and framing it even in the historical context of reparatory justice, as executors that they were, they actually have the strongest bridge to reparatory duty when you look at your case. And it goes on, he was saying, because executors are fiduciaries, this is an argument. I mean, given the arguments that you guys have put out there, the Browns argument could be the bank assumed obligations of loyalty and care. Beneficiaries were made vulnerable. Already established, even through the commission. The bank controlled information.
And that's why I mentioned it's the institution.
That's right. And the beneficiaries relied on the bank's representation. The bank, in this case, is the strongest bridge to reparatory duty and justice. The bank. Now, I know, you stated earlier, much as with what's not been allowed, right? But the bank is not off the hook in this here.
No, not at all.
The bank's not, no, man.
Not at all.
No, you can't. So, when you think in terms, and I'm placing this case as, and I know of another, same thing, reparatory justice, because it has deep historical, intergenerational harm attached to it, as your case does.
Correct.
Right? And as much as we talk about reparatory justice, we need reparations and so forth, these are some of the current events or current circumstances that we can and should be addressing.
Yep.
Please hold, caller. Go ahead.
And I'm glad you brought up that point.
Turn your radio down, caller.
I'm glad you brought up that point about the bank.
Yeah.
But me personally, I also see a disconnect. And I'm not calling any names. I'm just going to make it broad. I see a disconnect from our politicians.
Well, it gets back to, I think Khalid brought it up. I think two other callers brought it up in terms of parliamentary even responsibility.
You know,
this here.
yeah.
And it gets at the role that colonial governments do play in even reparatory justice issues.
Yeah, the fact that...
Caller, go ahead, and there's a lot of noise in our ear, screeching, so radio or something on in the background.
Yes, can you hear me now?
Yeah, I hear you clearly. Go ahead.
Okay, can you hear me?
I hear you clearly, as long as the radio is not on in the background.
Good. You touched on a point, and I had to call back because when you mentioned this thing about the bank and having perhaps influence on some of the processes and all that.
Yeah.
But not just the banks. In this particular case, when I say this particular case, regarding land grab and the whole matter that was before the commission, I wouldn't discount the role of the government also, right?
Yeah.
I just mentioned that.
In
Good point.
the case that I presented and effectively was not allowed to present, right? Which was regarding my grandfather's property. Now, let me say this. I'm just going to put it, without calling any names, I'm just going to say it to you in plain terms. What happened. This could be researched. It's there. It's deeded. It's archived. It's there. It's a public record. Harley School was sold to the Bermuda government somewhere around 1952. That property was originally owned by my great-great-great-grandfather. He sold it in 1853 to a William King.
Say it again. Which primary school? You said
and it was 3 acres that he sold.
Okay.
And that individual sold the government in 1952 6 acres.
Okay.
When he only purchased 3 acres, he sold 6 acres to the Bermuda government. The Bermuda government basically took the property because they wanted to build a school. And when they decided to convey it, they found out, we only purchased 3 acres of this guy. The other 3 acres, the individual who owns that is dead. So they put they stamped their name on it. Right? So that was 3 acres there. But included with that particular portion or that particular possession of that heir, which is my grandfather.
Right.
There was also another piece of property. It was a half acre. Because if you took the strip of the land and went straight on over, you end up on Horseshoe Bay. You end up on Whale Bay.
I got you.
Whale Bay was a half an acre of property, and it had a house on it called Whale House. When you look at the history of Whale House, you see the name Anthony Darrell, which is my great-great-great-grandfather. And then his 2 sons inherited that, which is my great-great-grandfather, William and Aaron. Aaron died before William. Aaron died in 1864. William died in 1869. And then Daniel inherited all of his property. They inherited their property. They never sold it. You'll see lists in the papers that property for sale, fishing business for sale, Whale House. never sold. In somewhere around 1930 or so, somewhere, my grandfather was a ferry driver, and the Secretary of State came to Bermuda, and his wife fell overboard, and he jumped overboard and saved her, and he got a medal award and money and whatever the case is. But because he used to ferry people like that, he knew that there was and you would know this historically, that at one stage they were planning to cut Bermuda across from like Horseshoe Bay area all the way to the Sound and have an entry straight from the South Shore straight to the Sound, because that's where the first airport was going to be.
Right, Darrell's Island.
And that's what they wanted to do.
Yeah.
But the guys, Conyers and all the individuals, they got involved and they convinced it, no, let's do St. David's. But he knew that. So he took the deeds and left the deeds, took the deeds to Canada, to his sister, up in here, where I live. He gave it. So all my life, we understood that Grandpa earned Whale Bay. He died 1947. So he died. Now, the Commission of Inquiry is going on in 2019, right? 2020. And you would know that during that period of time, there was a negotiation going on with a particular hotel, trying to get funding. Is that correct?
Yeah.
Suppose the hotel, there was a dispute on land, particularly a beach, during that time. What do you think the ramification of that would be?
Well,
I would think the funding would get stuck.
Yeah. I mean, I think
Because
of
even beach.
Don't we have? I mean, I'm not saying it's the same thing, but when we know the history of Sonesta Beach property in the Wilson clan. Where at least they were written into any developments on that property could not remove them from any commercial development, hotel property. Didn't remove the Wilson family from their property or something like that.
He was dead. But in the case of my grandfather, he was dead. And his children, I mean, I have to say, a lot of my family suffered, I would call, retardation, right?
Okay. Intergenerational harm. Go ahead.
That's a fact of life.
Right.
It's a reality of life. Some of them were barely literate, right?
All right. So mental health challenges, we would say today.
And literally mental health challenges. Literally.
Yeah.
And that was taken advantage of, seriously taken advantage of. So when, and in my cousin's testimony, she talked about some individuals coming and grabbing her father and pulling a gun on him because they thought he came home and found them looking in his house because they assumed that he had the deeds, I presume, right? Well, but what she didn't know is what were they looking for? They were so obviously they left on. She said they pulled a gun on him, and they obviously left disappointed. That's why they pulled a gun on him. What were they looking for? They obviously weren't looking for his property up in the area of Heron Bay. What they were looking for, it was probably the lawyers or the individuals who were trying to pull together a package to make sure that when they sold Ludwig property, that it had a beach. Right? So now I can make a claim, and I could be completely wrong, that maybe the reason why my case was thrown out is because they needed to sort of make sure that wasn't something that was being contested while those people were trying to get the funds for the hotel.
Well, it would have been a precedent.
I could be completely false, but because of how it was structured, there's no independence. You know, you have like the caller before mentioned, for example, in the States, a senator cannot become
but in the U.S., that's in the U.S. example model he was speaking to.
The AG's office is a political appointee, so it's not separate powers.
Yeah.
And what happens is even the commission itself, the way it's appointed, you could have influence from the banks, You can have influence from government, from all different areas. The question is, independence of the commission of inquiry would mean that, aside from just the judge, which would normally no disparaging remarks to her, but aside from her, who intervenes to see that there's impartiality, right? Because of the issue of separation of powers, how do you get that sort of impartiality where someone can scrutinize it from above to determine that fairness is being happening, and when somebody's case gets dismissed, is not dismissed for some ulterior reason? There's nothing there to prevent that because there's no separation of powers.
Wow.
So that becomes what you mentioned there excited that point in my particular case.
I appreciate you sharing that and giving some context.
It's not only a case of the banks and the strength of the banks, but it could also be the strength of politics in terms of what is a political imperative which is being interfered with.
Well,
that's another possibility. I'm not saying it is or is a fact, something as a literal fact, but it's also a possibility.
All right. Appreciate you, my brother. Always. Yeah. Woo!
Yeah.
Yeah.
Well, I want to
sum up.
Yeah, I want to just continue where I was trying to go before the callers call back in about this disconnection with Parliament and politicians.
And that's going to be a good way for us to go. Close out. You don't want that there because that's key.
I have a mentor that I speak to quite often, and we have discussions. And I didn't really understand his terminology with what he was saying to me first until I digested. And he asked me, what is my vote worth? I said, I don't know. How much is yours worth? He told me his is worth $1 billion. And he was trying to let me know that taxation without representation is what's pretty much being at play here. We all pay taxes, and politicians get paid and got a paycheck. And from what I've seen, heard, and understand, our politicians are disconnected with this commission of inquiry. Our present politicians, from what I'm seeing.
Well, given the fact that Parliament can make a case for,
and when I say disconnected, and I'm only speaking from even my mother's experience, the freedom fighter. And I'm not saying that she felt let down because she's diehard PLP. PLP can't do anything wrong.
Well, I talked to your mother.
PLP can't do anything wrong.
Well, no.
Well, let me tell you what I'm saying.
But go ahead.
I feel she was let down with all.
She certainly was.
She
wouldn't say it.
No, she wouldn't say it. With all the other elders.
Yeah.
Her brothers and sisters who brought this matter to the forefront. They're now passed on. And it's due to the wickedness of the bank, the UBP, the government, and I'll even quote Sir John Swan, who played an integral role in the theft of my family's estate. I've had politicians come to my house when they were running for office, and they all said, oh, this is going to be the #1 mandate. I heard their voice since.
Well, again, what you're speaking to, George, again, is this here. You're answering the question of how colonial government, Parliament, you're naming, as you cited, all those persons that we know who are of Bermuda government, as a colonial government, there's no disputing that, who have the power to make some decisions, and as you have identified, some have made decisions in error. Some have chosen not to decide at all from their position of political legislative power on this. Even today, given the previous callers that we've had who said, well, Parliament can do that, they haven't done. Yeah? So, governments are complicit in Bermuda land grabs and have been historically complicit in Bermuda land grabs. And even in this case, your case, and maybe one or two others that are out there, where the government, the Parliament, can and has a position of power to make decision, but has not. Tells me you're complicit.
And it's very important before we end this show, Isabel, if you may.
Go ahead.
That I need to listen to the audience and the public to know this is not a Brown matter. It is Charles Brown and George Brown representing the ancestors and the beneficiaries of the late John Augustus Alexander Virgil. So I just wanted to put that out there. That is, because even when I talk to people about this matter, they go, oh, there goes the Browns again. No, me and Charles is just representing our ancestors and the beneficiary of John Augustus Alexander Virgil.
Hey, it's a pleasure, my brother.
And on this last note, I'm fired up over the judgment by the Chief Justice. Because I know that the journey continues with the pursuit of justice, which is my passion in life right now and my purpose.
Well, and as we say, the struggle continues. We don't fight on any one front. We fight on all fronts. And this is a case that has fights on all fronts. And let me just say, as we close out tonight, people, we're grateful and we're thankful for Bermuda Dry Wash. It's always great to see a local business and entrepreneur grow. Now, she's going from mobile detailing to
corporate detailing, empowering young man.
There you go. Got the young brothers out there learning a skill set, a trade, and business. Yeah. Sister Kim.
Yes, right.
Sister Kim. Let me just say, my brother, I appreciate you and the family indulging us and keeping us informed. And while there may be many people who might feel it's a no-win battle, I like to take the position that it's the long fight, people. It's the long fight. And as has been shared here tonight, what did they say? Some people, you see the forest before you see the trees. Yeah?
Yeah.
Yeah, you got to see the forest before you see the trees. Take that journey, because this is certainly a case that stretches into reparatory justice. Reparations is an argument of this case. And again, people, because we like to make the connections to what's going on globally, I hope you, and I know you have the intellect and the common sense and the intelligence to see the connection, because I've sought to make the connections to what's going on in the Caribbean, but these land grab cases are global right now. Certainly we know of what is in South Africa, but certainly across the Caribbean. Bermuda actually is an example, and they are subjected to what some may call disaster capitalism, because their land grab is connected to those who have capital that is used on islands like them. When you talk about hurricanes and disasters and lands being wiped out, I think Jamaica's going through some of that also in St. Elizabeth. Disaster capitalism. Some may frame it even within the context of what you see billionaires doing right now, even in the United States and across Europe and everywhere else, gobbling up everything. But go ahead, close out.
And on the last clears out piece from my perspective is that we respect the court's decision. We respect the process. This conversation tonight was in no way to criticize the Chief Justice. All we done was spoke about the judgment, the delay, and our perspective.
Well, what we did do is offer critique.
Yes.
Yeah. So we make no apologies for constructive critique, supported with evidence. All right.
Mm-hmm.
And as you frame some things, yes, on your opinion, we also added substance with evidence to some of our own critique. All right. So I just want to make that clear.
And I would just go on record, just for the public to know what's next. Mm-hmm. We will be filing an appeal within the appropriate time frame.
There you go. Coming soon.
Absolutely.
Coming soon. On that note, have yourself a safe night, people. Keep
Bermuda Live on YouTube. Subscribe now.